case briefs, and so much more. LSData's got what you're looking for.
In the 2015 case United States v. Silver, defendant Sheldon Silver, former New York Assembly Speaker, claimed that the U.S. Attorney's comments regarding his indictment on charges of public corruption violated rules governing public statements by federal prosecutors and caused irreparable harm. He filed a motion to dismiss the indictment or review the grand jury minutes. Before Silver's arrest, numerous newspaper articles reported on the U.S. Attorney's investigation into Silver's alleged misconduct, and his eventual arrest was widely covered in the press. The United States District Court for the Southern District of New York analyzed whether the U.S. Attorney's comments were prejudicial enough to warrant dismissing the indictment or reviewing the grand jury minutes. While the court acknowledged that the U.S. Attorney's conduct was concerning, it ultimately denied Silver's motion as it found no substantial influence on the grand jury's decision to indict. The court emphasized that the case should be tried in the courtroom and not in the press, asking the clerk of court to terminate open motions at docket numbers 12 and 27.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.